Hey guys, Chicago injury lawyer Scott DeSalvo here, and in today's video we're going to talk about what is the difference between a settlement, a trial, an arbitration, and a mediation. You might hear those terms thrown around in the context of an injury case or even other kinds of cases. So I thought, I explain that a lot to my clients when those topics come up, so I thought I would shoot you a video and explain what all those are and how they work. So a settlement is usually just a settlement that your lawyer reaches directly with the insurance company. Okay? Now, a settlement can be reached before a lawsuit's filed, or while a lawsuit is filed, or after the lawsuit is filed in your personal injury case. I would say the vast majority of my settlements are before we file a lawsuit, so there's no judge involved yet. The advantage of doing that is usually the case costs, the amount of money I have to spend to get your money on your case is lower. Sometimes the offers are lower pre-suit than they are when the case is in suit, but that's neither here nor there. Basically, a settlement requires your approval and your signature on what's called a release. And then once that happens, your lawyer has to contact any insurance company, lawsuit loan company, doctor, or medical provider's office who have filed a lien or have any kind of claim against your settlement. Okay, that can even include if you owe back child support and we're notified by the state of Illinois, we might have to pay some of your settlement out to the state of Illinois for back child support. So be aware of that. But I'm not going to go into the details of how all of that is calculated. I might shoot a video of that later, but I'll be honest with you, it can get so complicated. All the calculations, that shooting a video like this is probably it's going to be too hard to understand, too many moving parts. This is what I always tell people though. Whether I get you $1,000, $100,000, or $1 million, you're always putting money in your pocket. Okay? I'm not going to collect a penny unless you are putting money in your pocket. That's whatever the liens are. And I am very, very good, very, very quick, and very, very efficient at negotiating all those claims against your case down as low as possible, because every dollar we take away from a doctor or an insurance company or somebody like that goes directly in your pocket. So that's how that works. So that's a settlement, right? Your lawyer gives you the papers, you sign them. Usually 30 to 90 days later, you've got your check, sometimes longer if the state is involved or the federal government is involved, because it can take them a little while to let us know their numbers and to respond to us. So patience is a virtue, but the sooner we get going on it, the faster we get it done for you. So that's how that works. Now, the other thing that I wanted to talk to you about is what is a pretrial? It's a pretrial settlement conference. So pretrial settlement conferences, or pretrials as lawyers call them, is a meeting between the insurance company lawyer and me, and sometimes you, and sometimes the insurance adjuster. So I've done pretrials where it's just me and defense attorney, or where it's me, my client, and the defense attorney. Sometimes it's me, my client, the defense attorney, and the insurance adjuster. And that is a short meeting. A lot of judges squeeze them in. If it's a judge who does trials, they squeeze them in usually at noon or early in the morning before their trials start to try and help people resolve their cases. So in a situation like that, similar to like when I prepare a demand letter and send it to the insurance company, in a pretrial conference, I prepare a pretrial settlement memo, and I usually try and keep it short and to the point because the judge has limited time to read it, right? Usually pretrials are an hour or less. They're often 15 minutes. And, you got to have some idea of what you're looking for in the case, and the other side has to have some idea on their end as well, right? Like, what are they willing to pay? And if we're not close, the settlement's probably not going to happen. It can get continued, right? So some judges are really good at pretrials. They knock them out. They twist everybody's arm and they get it done. Other judges, I don't know. I don't really know if it's the judge's fault, though. I'll be honest with you. I'll say, just like anything else, there are some judges who I think are more efficient at it than others, but that doesn't necessarily mean anything. For example, I know lawyers who like judges who I would put on the second tier of being good at pretrials, and I know other lawyers who put those judges at the top tier. So I think there's a big factor, or a big percentage of this that really comes down to, personal preference. That's what I was thinking of. So anyway, that's a pretrial. That's when you have a short meeting with a judge and you're able to settle the case. Your appearance might be required or it might not be required, depending on the case. Because pretrials are so short and quick, I usually ask my people to be available by phone. And we get to a number, I call you, I explain it to you, and then, obviously we talk before the pretrial so we're both on the same page. So that's how you settle a case in pretrial. Now, what is an arbitration? An arbitration is either a court-ordered mini trial or a mini trial that you agree to, where instead of a judge or a judge and jury, you are you're doing like a submission longer than a pretrial memo, right? But just a piece of paper that contains basically a summary of the entire case. And then at a mediation, we will have to call witnesses. So usually we don't have to call doctors as witnesses or take an evidence step of a doctor, because the doctor's opinions and medical records can go into evidence with that arbitration submission. And we mainly just have to establish your accident, like how it happened, who was at fault, and we have to establish your pain and suffering and your loss of a normal life. I'm sorry, I haven't even had coffee yet. I have my coffee here, and I just hopped in the car and started driving to work. I'm actually surprised by all this traffic, but I haven't had any caffeine today. And I literally jumped out of bed, hopped in the shower, got dressed, and hopped in the car to go downtown and catch up on paperwork. My office is a mess. I got to clean it. But I got to do that on weekends. It's just too busy during the week. So going in on a weekend to do that. So that's why my mind is wandering here. I'm going to drink a little coffee. Maybe that'll help. My point is, I got to call you as a witness. And if we have any other witnesses who saw what happened, we got to bring them. And if we have a damage witness, like if you're married, I often will say bring your husband or wife, and we'll call them as a damages witness, Usually an arbitration is short. Usually if it's a mandatory arbitration, which is a arbitration required by the court with 3 judges who decide, those can take up to an hour and a half to 2 hours, but usually many of them are 30 to 45 minutes long if it's a straightforward rear ender, right? So my presentation has to be greatly abbreviated in an arbitration. Now, you can pay for an arbitration as well, and if you pay for one and it's not court ordered, then we have to pay for it. Usually we pay for half and the other side pays for half, and then we go to arbitration, and usually they will block out, I think, 2 hours or 4 hours on most cases to do the arbitration. Sometimes they will block out far more than that. Sometimes they will block out 8 hours. Sometimes arbitrations can be multiple days. But I would say the vast majority of arbitrations in injury cases are, 2 hours to 4 hours, so a little bit longer. gives us more of an opportunity to make a opening statement and a closing argument and really highlight the evidence for the judge and call additional witnesses. So if you have a serious permanent injury, I'm very likely to call more witnesses at an arbitration that isn't a mandatory one ordered by the court. Now there's an important difference between the two kinds. The court-ordered mandatory one that happens in smaller cases is anyone can reject that. So you've got a period of time after the arbitration where anyone can file a rejection at court. You have to pay a fee to reject the judge's decision. In the other kind of arbitration, it's binding. Okay? So if you're paying for it and you've got a retired judge who's hearing mediation cases now, it's literally just a situation where that's how it works. Okay? It's binding. The judge makes a decision and that's it. And we sign an agreement before the arbitration saying we agree it's binding. We agree to be bound by the situation. In fact, oftentimes they require you to dismiss your case in court because it's going to be resolved at mediation one way or the other, right? So that's how they get you to make sure that you comply and you don't want to attack the agreement to mediate, to arbitrate. And as a result, it's, arbitration is somewhat less popular. When I was a younger lawyer, it was more popular, I think, because it was a way to get rid of cases much quicker and for less money. But the problem is, if you end up with a judge who is having a bad day or is overworked and is tired or is a little bit too friendly with the other side, like they worked together or they had a bunch of cases together or something like that, it can create a weird situation where if we lose the case, the client will see, oh, the judge likes that lawyer. The judge doesn't like you. The judge likes that lawyer. Do they know each other? Is the fix in? And then the client, the injured person can understandably say, well, dude, wait a minute. Like, the judge likes that guy. He doesn't like you. Do they know each other? Do they golf together? And then if they get a bad outcome, like a tiny verdict or a not guilty, the client's unhappy. And I think lawyers are suspicious about that too. I'll talk to some of my colleagues after they get a verdict that they're not happy with or a decision they're not happy with, and they're mad. They're very mad, and those sorts of thoughts creep into lawyers' heads too. And so that's why I think arbitrations aren't that popular anymore. So let's talk about mediations. Mediations have sort of replaced the popularity of arbitrations. Here's the sweet thing. Mediation is like a pre-trial conference, a settlement conference. We show up, they show up, we do a submission, sometimes they do a submission. We can give the judge private information, they can give the judge private information, whatever it is, right? And then the judge literally goes to work and tries like hell to settle the case. So some cases can be mediated in 4 hours. Sometimes they're a full 8 hours. Sometimes cases take multiple mediations to actually get settled. Good mediation judges will tell it to you straight. Good mediation judges will go to the other side and raise merry hell. And if they come back and say, I don't know what their position on this is, I don't know why this is going this way, I don't think they're offering enough money. The nice thing about mediation, just like a pretrial, it's not binding. We can walk right out, and I have. I would say mediations are very effective at resolving cases, and a lot of the judges who do it are just amazing at it. In fact, I'm trying to think if I've had a mediation judge who I didn't think was really, really good, and I cannot think of a single one. I mean, I think it's a really good format. I think mediation is a really, really good format for that kind of thing. And looks like we had a pretty big crash there, explaining why traffic was all messed up on a Saturday. It's crazy. Anyway, so that's the difference between a settlement, a pretrial, a arbitration, and a mediation. Everybody knows what trial is. You go to court. If it's a jury trial, you pick a jury, and that's it. That's what you do. And then whatever the jury says goes. So that's how those work, folks. Anyway, pretty long video this time. Sorry if I bored the hell out of you. But at the end of the day, I thought it might be useful for you to know the difference about the different ways that injury cases end up getting settled. So anyway, hope that information helps you. If you know somebody who needs a lawyer in an injury case, or you have questions, please feel free to give me a call. It's always free and no obligation. 312-895-0545. Again, 312-895-0545. Thanks for watching. Take care.